Hello and welcome to the conversation with Rifik Barber, who is a research fellow at the Asia Pacific Center for the Responsibility to Protect. And the reason for today's conversation is her recent article, which was published at Just Security, which talks about an issue which is possibly one of the key issues for displaced Syrians and Syrians as a whole at the present time. And that is the continuation of cross-border aid delivery to northern Syria. As you are probably aware, the aid is in a way being held hostage by a decision of the UN Security Council, and primarily Russia that holds veto power, on the premise that the aid should be delivered through Damascus, through the Syrian regime, rather than directly through the border outside of control of Assad's regime. This places more than 3 million people in Idlib in a situation which is already dire in itself, where the only helpline that they have for the aid that they depend on may be cut when this resolution is not renewed. What Rifik Barber wrote in her article is possibly one of the most important points in the discussion on this issue, where she basically questions the assumption that the UN Security Council approval is in fact the condition for the aid to Idlib to be legal. Her article that I mentioned in Just Security is a summary of a longer article that is forthcoming in the Yearbook of International Humanitarian Law. And it provided the spark for renewed conversation that exists in fact, ever since the resolution 2156 was passed in 2014, we had a letter that was signed by the leading experts on international law who questioned this assumption that UN Security Council's approval was required for this aid to be legal. First of all, Rifik, thank you very much for agreeing to speak to us. And let me immediately ask you, why has the conversation around the delivery of humanitarian assistance in Syria focused so exclusively on the Security Council when its mandate is not for humanitarian assistance, but for peace and security?
Yeah, thanks so much, Rafik, for having me. And thanks for all those nice comments regarding my article. In terms of why the conversation has focused so exclusively on the Security Council, I think probably the starting point is that under the UN Charter, the Security Council has responsibility for international peace and security, not for human rights or humanitarian assistance primarily. But the Security Council in the UN system under the UN Charter has particular competencies that are unique to the Security Council. And that has been perceived, one of those competencies has been perceived to be providing the authorization for humanitarian assistance. So in 2014, the Security Council passed a resolution 2165, which provided the authority for UN organizations and their humanitarian partners to provide humanitarian assistance in Syria via for designated international border crossings. That resolution was incredibly important at the time because the Syrian government had not been authorising the provision of assistance in non-government controlled areas in Syria, and humanitarian organisations were not able to provide sufficient assistance in those areas. So the resolution was incredibly important, provided the political basis for the UN to start providing assistance from across international borders, so from bases in Iraq and Turkey, and initially from Jordan as well. And it was also understood to provide the legal basis for the provision of that assistance. As I said in my article, the Security Council authorization at that time did also have a not so positive effect from a humanitarian perspective. And I think that was to sort of enshrine the assumption that Security Council resolution, that Security Council authorization was necessary for humanitarian organizations, i.e. the UN, to provide humanitarian assistance in non-government held areas without Syrian government consent. So since 2014, that resolution has been renewed annually. It's been whittled away over time. So now we're in a position where Security Council authorization only extends to one border crossing in northwest Syria. That's obviously up for renewal in a few days. But since 2014, the conversation has, as you said, completely focused around Security Council authorization.
This in fact has allowed Russia to kind of hold this over the head of not only Syrians who are directly affected by this, but also various different international counterparts, which allowed it to bargain for what its political aims are. But one key question here is this assumption that the UN Security Council approval is required for the delivery of aid, is it rooted in international law definitively?
So it is rooted in an interpretation of international law. So there's international humanitarian law, and there's another body of international law regarding state responsibility. International humanitarian law is generally understood to mean that the consent of the host government is required in order for states or international organizations to provide humanitarian assistance, but that states cannot arbitrarily refuse consent to humanitarian assistance. What international humanitarian law does not say, the question that I think is really significant and is left unanswered, is if international organizations, i.e. the UN, want to go ahead and provide humanitarian assistance anyway, where consent from the host government is arbitrarily withheld, that is legally withheld, then what is the status of that humanitarian assistance provided where consent is illegally withheld? And international humanitarian law does not answer that question. It is generally taken as the starting point that the provision of humanitarian assistance in another country without the consent of the host state is a violation of state sovereignty, and in particular a violation of territorial integrity. And what I think is really interesting is that assumption regarding a violation of sovereignty and a violation of territorial integrity in particular is very often taken as the starting point without that assumption really being questioned. And I think that assumption glosses over two really fundamental questions in international law that I don't think are definitively answered. The first is, what exactly is the concept of territorial integrity, and what does it protect specifically? What is the concept of this notion of territorial integrity? And secondly, what constitutes a prohibited violation of territorial integrity? And there is some jurisprudence and a lot of scholarship on both of those questions, but I think if you look through the jurisprudence of the ICJ and you look through all the scholarship on what does territorial integrity actually mean and what constitutes a prohibited violation of territorial integrity, in my view, you come out with the answer that principled humanitarian assistance, that is humanitarian assistance that is impartial, independent, provided for an exclusively humanitarian purpose, with the consent and the full cooperation of local authorities and communities, in my view, that does not fall within the definition of a prohibited violation of territorial integrity.
You are far from being alone in this opinion, and this is the subject that I would like us to address. Like you mentioned, the International Court of Justice in 1986 held that, I quote, "there can be no doubt that the provision of strictly humanitarian aid to persons or forces in another country cannot be regarded as unlawful intervention or as in any other way contrary to international law." I would say that is quite clear. But in 2014, a group of leading international law experts signed a letter unequivocally stating that there is no legal barrier for the UN to deliver aid across the border. They enumerated 3 concrete reasons why this is so. And perhaps maybe you can walk us through these 3 reasons better than I can, if you would.
I'm actually not sure I can walk you through those 3 reasons completely off the top of my head. But what I can say is that that letter was talking very much about international humanitarian law, which is a bit different than what I've been talking about and what I was talking about in my Just Security article, which is the issue of territorial integrity and also the issue of necessity as a circumstance precluding wrongful conduct. But you asked about the letter, so just to go back to the international humanitarian law issue. So I said before, international humanitarian law provides, it is quite well understood, that consent is required for the provision of humanitarian assistance, but that it cannot be arbitrarily withheld. Arbitrarily withheld means withheld without a good reason, and it's pretty well accepted. I don't think anyone really disputes the fact that in Syria, the Syrian government is arbitrarily withholding consent to the provision of humanitarian assistance in non-government controlled areas. So if my memory serves me correctly, that 2014 letter was arguing that in circumstances in which consent is arbitrarily withheld, then international humanitarian law does not prohibit the provision of humanitarian assistance without that consent. There are also different views on who is required to consent. And again, I'm sorry, I can't remember exactly what the arguments were in that letter, but it is possible that that letter was presenting the argument that in non-government controlled areas, it is actually the local authority that is required to consent, not the host government, particularly in circumstances in which the provision aid is not actually even going to transport through a government-held area, i.e. in a cross-border humanitarian assistance scenario.
You, in fact, remember very well. These are, in fact, 2 key reasons. They cited first that the United Nations clearly meets the first condition for legitimate humanitarian action, which requires it respects the principles of humanity, neutrality, impartiality, and non-discrimination in delivering aid. But the 2 other reasons are specifically that in many areas these territories are controlled by opposition groups, and that in such cases the consent of those parties in effective control is all that is required by the international law. But this question of arbitrary denial of humanitarian aid, just so we remind ourselves, Russia is insisting that all aid goes through Damascus, through the Syrian regime, when in fact more than 80% who are by the UN categorized as in dire or catastrophic need of humanitarian aid are in Idlib or northern Syria. Yet not one convoy to date has been allowed by the Syrian regime to that area. And in that, not to mention the fact that the displacement of people from the regime-controlled areas like Dara and elsewhere to Idlib continues, even to this day. That displaced population in need is in fact growing in those areas. That in itself constitutes a very strong reason for the argument that the cross-border aid is legal even without the UN Security Council approval. But let me ask you about this is where we get to the original question. Why are we talking about the Security Council approval instead of other legal bases for the UN to continue delivering aid? And the two key entities here are the Emergency Relief Coordinator and Interagency Standing Committee, who seemingly rely on a legal opinion from the Office of Legal Affairs of the United Nations, which says that the UN Security Council approval is required. As we could see in the recent statement from the 7 leading UN agencies on the ground and the 41 NGOs that also followed that through. Has anybody seen this legal opinion from the Office of the Legal Affairs of the UN so that we can test it, that we can debate it? Because I could not find it anywhere.
So I also haven't. I think it's an excellent question. I also haven't been able to find the legal opinion, and I haven't spoken to anyone who has seen or read the legal opinion or in fact even knows that it exists. I don't know if there is an actual legal opinion. It's been suggested to me in a couple of my conversations that there probably isn't an actual legal opinion. But as you suggested in your question, it seems incredible to me that there is all this planning on the basis of this sort of legal kind of status quo that Security Council authorization is necessary for the provision of humanitarian assistance in non-government controlled Syria, and yet that legal opinion maybe doesn't even exist, and if it does exist, then it's not been shared and no one is able to sort of look at it and interrogate it. So that is to me a huge problem.
How do we go about advocating with key states and others to, in fact, make this legal basis public? So, as I said, so it can be tested and debated in face of all these other arguments by leading international scholars or International Court of Justice and so on.
Yeah, I mean, it's a tricky question because I think this conversation is just not really a conversation that has been had. So I don't know if there really have been any asks out there by anyone to see this legal opinion. And I should say, in fact, I should have prefaced all my answers with this at the start, is that I'm not, I'm an academic at the moment. I'm not working with the UN or with any humanitarian organization with operations in Syria. So I'm not in the discussions. I'm not in any of the coordination meetings. So I'm very much speaking from afar. So I think I need to make that quite clear that, I don't have any sort of particular insight into, the internal goings on of all this. In terms of whether there is or isn't a legal opinion and what it does say. But sort of in terms of how to take it forward, I mean, I think having this conversation right now is really important. And I think asking about the legal opinion and if there is one, and if not, then why not? And can we have one? Is a really good place to start. I just wanted to touch on something else that you raised in your comments before about the UN and humanitarian organizations and why the focus has been on the Security Council. I think it's incredibly important to make aware for all your listeners, and like maybe this is obvious to some, but perhaps not all, is that many of the UN agencies and a number of the NGO humanitarian organizations have operations in government-controlled Syria and non-government government-controlled Syria. And obviously they're involved in an incredibly difficult balancing act with the aim to preserve their access in government-controlled parts of Syria as well as their access in non-government-controlled parts of Syria. So if someone was to come up with a legal opinion that said, okay, UN, you can go forth and provide humanitarian assistance in opposition-controlled northern Syria without either Syrian government consent or Security Council authorization, that would presumably be an incredibly politically difficult thing for the UN to do. Who knows whether they would be able, whether that would be even possible for them to contemplate without losing their access in Damascus and in government-controlled parts of Syria. So that's obviously a huge part of all of this, and I think that's really underpins why the conversation is focusing on the Security Council, because anything else probably really seems too politically difficult to contemplate. So we obviously can't underestimate those difficulties, but I don't think that means that we shouldn't be having the conversation. Just one more comment on that 80% figure. So I think one issue is that 80% of the, and I think it was 80% from memory, of the people in catastrophic humanitarian need is from the humanitarian needs overview. So far as I know, that's a figure that I came up with trawling through all the pages and pages of tables at the back of the humanitarian needs overview, and looking at what districts and areas were in government control and what were in non-government control, and who was categorized in severe need and catastrophic need, and just in need, or whatever the other categories were. So I don't think this figure of 80% of people in catastrophic humanitarian need are in opposition-controlled areas is kind of out there as a thing. I think what you more often hear is that there's a huge number of people in need in government-controlled Syria, and if memory serves me correctly, I think there's actually much more people in need in government-controlled Syria. So I think if the UN is making this equation, thinking, well, there's all these, how many million people, I don't know off the top of my head, in need in government-controlled Syria versus 3 or 4 million people in northern Syria, then maybe we need to sacrifice these people in northern Syria in order to meet the needs of these millions of people in government-controlled Syria. But if you look at the people in catastrophic humanitarian need, whose lives really depend on humanitarian assistance, then the vast majority of those are in non-government-controlled northern Syria.
No, absolutely. Especially when it comes to your comment on the UN navigating politically the reality on the ground. If I may get personal, as a Bosnian who has lived through this similar navigation by the UN of the arguments of force, which we are basically, to use clear language, we are talking about the Syrian regime, in fact, using force and the UN having to succumb to this force in order to continue operations, as you described, to provide humanitarian aid. We are facing the same situation with UNHCR, which is failing to report on its own protection thresholds, or the fact that it has no access to the majority of returnees who are forced to return to regime-held areas from Lebanon, for instance, on account of exactly this. And we are aware of this, but that is precisely why this conversation has to happen, and not to reduce it to trying to appeal to humanitarian instincts of Russia, which we have witnessed very clearly over the last several years in Syria. But let me ask you, as we approach the end of this conversation, you advocate in your article for the role of the UN General Assembly in this matter. And more generally, this is your field of research, if you want. And we could see very often the role or the power of the General Assembly gets overlooked when it comes to issues in relation to Syria, when in fact the only UN accountability mechanism outside of the Commission of Inquiry, the IMM, that exists at the moment actually was born out of the action of the UN General Assembly. Is there a role for the UN General Assembly in this matter? And if yes, what that role could be?
Yeah, so there definitely is a role for the General Assembly. You mentioned my research focuses on the General Assembly, and it's precisely because of these sorts of situations that I've actually chosen to focus on the General Assembly, because there are so many situations in which the Security Council is essentially blocked by the veto, and there is simply no way around that issue. And at the same time, in these situations, the General Assembly has vast competencies under the UN Charter. It has the power to consider and make recommendations on any matter within the scope of the UN Charter. It's explicitly empowered to make recommendations on matters of international peace and security, and to make recommendations to assist in the realisation of human rights. So we cannot underestimate the powers and the role of the General Assembly in these types of situations. The General Assembly cannot authorise the provision of humanitarian assistance in the same way, or any type of intervention in the same way that the Security Council can. Well, there is actually an argument that it can, but the general view is that the General Assembly doesn't have the power to do that. But the General Assembly can pass resolutions with determinative effect. So it can express a view on the characterisation of a particular state of affairs in a way that can have subsequent legal or operational effects. For example, the General Assembly has on many occasions in the past made characterizations of state conduct, for example. So it's characterized state conduct as illegal or a violation of the Geneva Conventions, or as an act of aggression. It's characterized situations as threat to international peace and security. It's described regimes as legitimate or illegitimate. It's described the means by which a particular regime came to power as being valid or invalid. So it does have this competence to pass resolutions with some sort of determinative effect. It's not irrefutable, but it can attest to international consensus or majority view, depending on whether the resolution is passed by consensus or majority, on the characterization of a particular situation. And the International Court of Justice has quite explicitly recognised the competence of the General Assembly to pass these types of resolutions. In this particular situation, the General Assembly, I have argued that the General Assembly could feasibly pass a resolution describing the situation in opposition-controlled Syria, probably northeast Syria in particular, as a situation of necessity. We haven't talked yet in this discussion about necessity, but necessity is recognised in international law as a circumstance which can preclude the wrongfulness of what would otherwise be a breach of an international legal obligation. So it basically functions as similarly to a defence in civil law context. In order to invoke the defence, let's say, of necessity, you need to be able to show that the conduct in question was the only way of safeguarding an essential interest against a grave and imminent peril. The essential interest can be an essential interest of the international community, i.e. providing life-saving humanitarian assistance in a situation where humanitarian actors have said very unequivocally that there is severe or catastrophic humanitarian needs. So I suppose only the ICJ, the International Court of Justice, could probably make a sort of a definitive determination that this legal defence of necessity would be available to international organisations wanting to provide humanitarian assistance in non-government controlled Syria. But if the General Assembly were to pass a resolution describing the situation in Idlib, let's say, as a situation of necessity, then that could theoretically give international organisations, i.e. the UN, a basis upon which to go ahead and provide that assistance. And just to add, the third committee of the General Assembly in, I think it was October 2020, passed a resolution which went very, very close in its language to describing the situation in North Syria and possibly all of other parts of Syria, I can't quite remember, as being one of necessity and talking about the essential humanitarian needs.
Well, Rebecca, thank you so much for this conversation. I think that, as is obvious just from this last answer, there is so much material here to pick through in terms of advancing this conversation on alternatives to the current status quo, to the current, let me use a blunt language, blackmail, in which the Syrians crammed in Idlib are basically hostage to the decision of the UN Security Council and more particularly Russia's veto on aid, towards other conversations in terms of other legal basis for the continuation of providing the aid. Your contribution has been extremely valuable, including this conversation, and I thank you for that, and thank you for your time.
Thanks so much, Rafik, for having me and for the conversation, and good luck with your advocacy.
Thank you so much, and thank you all who viewed this and considered the arguments presented in this conversation. Thank you.